Inform you all that there has been a slight change in the schedule for the evening due to an urgent engagement of the Honorable Law Minister. We would be doing the book launch first, followed by the speech by the Honorable Chief Guest. Honorable Minister of Law and Justice, Honorable Judges, distinguished guests, ladies and gentlemen, and my dear friends, good evening. We are delighted to welcome you all today for the book release. What began and struck as a thought has today been conceptualized and compiled into this enriching manuscript, the Arbitrator's Handbook, a publication by LexisNexis and edited by Mr. Shashank Garg. Styled as a handbook, it is a collection of contributions from honorable judges who have expressed their views from the perspective of the bench, practitioners, both Indian and overseas, who share the practical nuances, and academicians who set out the law and concepts, all of who are stalwarts in the field of arbitration. The distinguished jurists have most graciously contributed to the handbook their wisdom and experience, making it a success. The Honorable Law Minister, Shri Kiran Rijiju, calls it a tool that would not only enlighten the reader on the law, but also the procedure. Other opening remarks and reviews have described the book as a must-have and read for all, an elucidation from world-renowned and leading jurists, a book effectively presenting the needs in order, and presenting new and refreshing perspectives on the most difficult and highly debated issues. The remarks highlight and speak volumes of the relevance of the handbook. My co-MC, Ms. Jayashree Parihar, and I, Shivang Diddi, once again welcome you all to this event and thank you for your kind presence. We would now request the distinguished guests to please release the book, and Mr. Shashank Garg. May we request all the other contributors also to come forward for a photograph? Can I request all the contributors who are present today to join us for a photograph of the book release, please? Honorable Justice Bakru, Honorable Justice Sikri, Ken, Sumit, Mr. Banerjee, Divikant, just on the stage for a photograph, please.
Our first speaker for the evening is our chief guest, Mr. Kiran Rijiju, Union Minister of Law and Justice, Government of India. At 50 years of age and a glorious trove of experience behind him, Mr. Rijiju has handled an illustrious portfolio of responsibilities, including discharging the duties of Minister of State Independent Charge for Youth Affairs and Sports, Minister of State for Minority Affairs, Minister of State for Home Affairs, as well as Member of Lok Sabha. A distinguished alumnus of Campus Law Center, Faculty of Law, Delhi University, and a lawyer himself, Mr. Rijiju's stance on arbitration as a remedy for dispute resolution has been nothing short of encouraging and facilitative. He has, on various occasions, appreciated Indian judiciary for playing a pivotal role in promoting alternative dispute resolution mechanism, particularly in arbitration and mediation. In an event recently, he lauded our courts for consistently adopting an arbitration-friendly approach, which has in turn strengthened the confidence of all stakeholders in arbitration. Ladies and gentlemen, please welcome to the dais our chief guest for today, Mr. Kiran Rijiju.
Namaskar. Honorable Mr. Justice U. Lalit, Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna, Justice B.R. Gawai, all the honorable judges sitting here, judges from the Supreme Court, and judges from the Delhi High Court, and I could see many eminent retired judges whom we still cherish their contribution and will continue to cherish for their future contributions. I'm seeing some of the eminent jurists, lawyers, and especially all the contributors to this beautiful book which we have released today, the Arbitrator's HandBook, all the invited guests. First of all, I would like to extend my congratulations to Mr. Shashank Garg and the entire team for this wonderful book release, which is no doubt going to become a very, very important book for everyone. I'm not going to speak long because when eminent judges are sitting here, I should rather give space to them. And we have to listen to the judges not only in the court but outside also. I always try to listen to the eminent jurist, what is there in their mind and what the government should do. So I always try to take suggestions, not preach others what to do. I have to leave for the meeting. You know, tomorrow is the vice presidential election. Me and my colleague MP, Hansraj Hanj, is also sitting here. I have to leave immediately, but having been invited here, I feel deeply honored to be part of this wonderful event. I know arbitration is a huge subject, and I don't know what to speak about, but to be very precise, we all feel India should be one of the important hubs of international arbitrations. And there are issues, there are concerns, and there are challenges I think together we can handle. I have a written speech here with me, but if I start reading it or speak out of this, it will take a long time. I'll just make a quick observation. There are some challenges which we need to address. And I take responsibility as a government representative here to ensure that whatever bottlenecks, whatever support, infrastructure creation, or any conducive atmosphere to be created, or all kind of policy support needed from the government, I fully commit to do that. Today only I have introduced a small amendment in the New Delhi International Arbitration Center Act 2019. I will not speak in detail because the amendment bill is just introduced in the parliament, so maybe hopefully by Monday, Tuesday, we could pass it. The purpose of that small amendment introduction is also to ensure that when we establish an arbitration institution, it must be robust, it must be friendly to everyone. There were certain issues when the Act was passed in 2019. Some issues were not foreseen that time. We are doing some corrective measures. And also, I have tried to understand how various arbitration centers in India are working. The Delhi International Arbitration Center, which is under the aegis of the Delhi High Court, is functioning very well. I must compliment Delhi High Court for nurturing a very successful arbitration center in Delhi. And likewise, the Bombay International Arbitration Center also is working very well. So the challenge with me right now is when we establish a pan-India arbitration center in Delhi, it has to be true to its name, to its value also. How to make India a center of international arbitration? It is easier said than done. Recently, I was in London along with the Honorable Chief Justice of India, and together we delivered our lecture. Justice Nageswar Rao was also sitting there with us. I saw Nageswar Rao ji sitting here a while ago. We really feel that we need to do many things to make India a hub of international arbitrations. Well, interacting with some of the people there, some parliamentarians, some eminent jurists, I got certain feedbacks, and I feel which we need to do it. India has the potential to become truly a global hub. But if we Indians don't trust our arbitration center, and if we prefer Singapore center or London or Hong Kong or Dubai, then the outsiders will not trust us. Indian judiciary is respected worldwide. And I was very happy when I was in the House of Commons. We have many people of Indian origin in UK. They all told me the Indian Supreme Court judgments are referred and quoted in UK. I really take pride in getting such kind of observations from a country which is source of the common law for us. The English people, they feel that in certain areas India has excelled beyond their expectation and we are doing better than them. So I take pride in our judges who have maintained not only the rule of law, but in guiding how the rule of law will percolate down to each nook and corner of the country. We run not by rule by law, but rule of law. So our judiciary has been playing very, very active role in the success of arbitration so far in India. The Supreme Court as well as all the high courts are very proactive in promoting arbitration in India. Despite that, there are certain challenges. If some parties feel that the Indian arbitral awards take time to be implemented, or if every arbitral award is to be challenged again in the courts, then we have to think, we have to find out certain mechanism. Nobody wants to delay the justice and the process of justice. We again challenge in any court, be it in high court or high courts or Supreme Court, then it is us who will have to take a call. We cannot tinker around with the provisions of the Constitution, but we can certainly modify certain provisions if required. I have tried to understand what is there that we can do to ensure that the spirit of the Constitution is maintained, but at the same time, the alternative dispute resolution mechanism which we have in places all around, be it mediation, arbitration, conciliation, they need to be strengthened. Now people tell me that as a law minister, what are you doing to reduce the pendency in the courts? When I took over as Minister for Law and Justice, the pending cases in India was just above 4 crore. Now, within a year time, it is inching towards 5 crore. Common people don't know. They say, well, as a law minister, you must do something. Please reduce the cases. It is not good that 5 crore cases are pending in various courts in India. Now, it is not an easy answer to give, but definitely I have a role to play, and I must ensure that Indian judiciary is strengthened further. Judiciary is independent, but it is not independent in conducting its various things through various support system. That support system, government is duty bound to create that support system for judiciary to do its duty. I fully commit myself for strengthening of Indian judiciary because Indian judiciary has stood the test of the time. Nobody can question Indian judiciary. But when there are debates and discussion, it is part of democracy. Sometimes some of the judges may feel that why judiciary is under scrutiny. And in the age of social media, nobody can insulate oneself from criticism, from being scrutinized. But having said that, we certainly must see where is the limit. So when I'm talking to the judges, talking to the lawyers, talking to eminent jurists, I would like to get your suggestion. I have many questions in my mind, but those questions can be addressed in the best possible manner if I get correct advices and suggestions. As I told you, government will take various steps if required for the strengthening of the arbitration process in India. Right now we have more or less like ad hoc kind of arbitration. We must move towards institutionalized arbitration. We have introduced mediation bill, but the Parliamentary Standing Committee has scrutinized and they have almost changed the face of the mediation bill which I had introduced in the last session of the Parliament. So I had a discussion with the members of the Parliamentary Standing Committee that the bill which I had piloted in the House, it is not diluted, but to a great extent, the main content of the bill has been changed if you see the various recommendations which has come from the Parliamentary Standing Committee. But this is good part of the democracy. This is beauty of our democracy. In the same manner, the Arbitration and Conciliation Act also, if necessary, will be revisited, and for that I'm very hopeful that I'll get the support from you all. Many of the retired judges are doing excellent arbitration works. And I know, it is the guidance of the senior lawyers and senior judges will have to work. Today we have many contributors for this important book which we have released today. I'm told that this book is not so much about the law and provisions, but it's more about the procedures. So on this, I just have to say one thing. From the time I took over as Minister for Law and Justice, I had stressed on simplification of the legal languages. If we make things complicated, it is suitable for some exclusive people. If we simplify it, it benefits the larger people. So, any process must be always simple. Now, why people want to avoid going to court and why people want to go to mediation or some informal arrangement which has been prevalent since long time is because the court procedure is too complicated. And these days, some of the high courts have started live streaming of the hearing. And during that, I have seen some people keep sending me the video clips of the comments of the judges and how the lawyers put up their case in the court. So I see most of the time there is a question of procedural. The cases being taken up, the judges are always telling you have not done this, you have not done that. So it's not more about the question of law, but it is about the procedure, this affidavit not being filed, this thing you should have done that, which is not attached, you should have approached that first. So much of arguments are putting on the procedural itself half of the time. So I'm very frankly telling this, but in Supreme Court, I have not seen how Supreme Court functions because Supreme Court deliberations are not being live streamed. But I am seeing the High Court deliberation. I have not seen the courtroom, how it looks like in my lifetime. But because of the live streaming of some of the high courts, I have started realizing that the procedures must be simplified so that let the judges take a call, but let not somebody get stranded just because he doesn't know the simple process of filing the case itself. So that is why when we talk about this handbook, which is more about the procedure, it is very, very vital and it will be handy for everyone. I can vouch for this. After some time, everybody will start buying this book and hold it. Anybody who is interested in arbitration matters will definitely buy this book. So Shashank Garg can earn lots of money. This book is going to have a great sale, like a hot cake. I'm very delighted to be part of that. And as I said, I'm not going to talk about legal aspects or high fundas here. I am a very simple man. I believe in simplification of things. Life should not be complicated. So, being a simple man, my outlook is very simple. When the the honorable senior judges are sitting here, the Supreme Court of Judges are here, we should hear them. They will give better comments and observations about this book. I am not a qualified person to speak in detail about this book, but definitely taking my responsibility into my stride, I can definitely say that any kind of help, support, cooperation required from the Government of India, I once again give my full commitment. Thank you very much for inviting me for this wonderful event. And whenever I come to any event, I see senior judges, especially the eminent judges of our country, I feel encouraged. I'm not exposed to judiciary that much, but slowly I'm getting to know the judges, the minds of the judges, the minds of the lawyers. It's very, very heartening for me to know the other side of their life also. Sometimes people say that judges are not interacting with the people. They are very, very confined to their own small world. But the life of judges is not that simple. They are also human beings. So once a lawyer or a person from lower judiciary is appointed, I think life doesn't change. Only the manner in which you function, your life may change. But as a person, you don't change. So during my time, I'm seeing lots of good things done by the judges. As a human being, as a judges, I always look forward to interact more and more. I try to go to universities as much as possible to try to talk to the young lawyers, because we will be needing lots of smart lawyers in future. We will be requiring lots of professional arbitrators, professional mediators, professional lawyers. Good students will become good lawyers and good judges. So I would prefer to go to more colleges and universities so that the Indian legal system is robust and the alternative dispute resolution mechanism in India is also robust. And for that, I will be forever there whenever I'm required. And once again, sorry for not sitting with you all throughout, because tomorrow is the vice presidential candidate there is a coordination group committee meeting. I'm there going to be one of the person who will coordinate the meeting. So it is a constitutional obligation, so I'll have to go. I feel sorry to leave halfway. It's not good to leave any program halfway, which is very much an act of indiscipline. But I must seek apology from all of you. But once again, thank you for inviting me here, and congratulations to Shashank and the entire team for great work and a beautiful handbook. Thank you very much.
The Honorable Law Minister has raised a very pertinent point on the support system for the Indian judiciary. We are sure that with the consistent and collective efforts being taken, the goal is not far. Thank you, sir, for your kind words, and we are deeply honored by your presence. We would now like to invite to the dais Mr. Kenneth Beale. Mr. Beale is a partner at King & Spalding, specializing as an international arbitrator and litigator. He works out of the firm's London and DC offices. He has been described as one of the best in the field. Ladies and gentlemen, Mr. Beale.
Thank you very much. And it's my real honor and privilege to make a few welcoming remarks. And I'll keep them short because I'm cognizant that I am what stands between you and 4 justices of the Supreme Court. So I will not make that obstacle too long. I first came to India for business about 15 years ago. And I remember it like it was yesterday. I was told, we have a potential matter, and could you go to Mumbai for a few days, it might be a week, to see what's happening there? And so I did. I had never been to India previously, and I ended up staying for almost a year. I ended up getting a PAN card, becoming an Indian taxpayer, and ultimately India sort of became what felt like a second home to me. Now that was 15 years ago, and I've had the privilege over those 15 years to watch the evolution of arbitration, and particularly international arbitration in India, evolution of the law and evolution of mindsets. And I'll tell you, if you had told me 15 years ago that I would be here today speaking after the Honorable Minister and speaking before not one, not two, not three, but four Honorable Justices of the Supreme Court, I would have said that you're crazy. But it's such a pleasure to do so. And it's been such a pleasure to watch the evolution of international arbitration here in India. And what I've seen, you all know far better than I do, but I can sort of speak from an outsider's perspective. I've seen an explosion in domestic arbitration in India, particularly for parties that want speed or less complicated proceedings than they might otherwise find in court. I've seen an effort, a very successful effort, I think, by the judiciary to clarify laws with respect to international and domestic arbitration in India. An effort that I think makes India increasingly more and more attractive for foreign direct investment, at least from the standpoint of dispute resolution. And we see, it seems like every month there's a new decision about something related to international arbitration in India, whether it's can Indian parties seat their arbitrations outside of India, how are emergency arbitrator awards going to be treated in India, how much can the judiciary become involved in enforcement proceedings, what are the limits of sovereign enforcement, and on it goes. And now, when I come to India, one of the questions that I often engage in is, how does India become a real hub, a seat of international arbitration? And the Honorable Minister was just talking about that. I'll tell you, if someone had asked me that question 15 years ago, my honest answer would be, well, I'm not so sure that that's possible. I don't know that our clients would ever consider India as a seat. But today, that's a serious question that people are asking. And you see institutions like the MCIA, the Delhi Center, the new center in Hyderabad, the ICC-SIEC, all trying to make this happen. I'm not going to go into the arguments of what needs to happen. I have my own views about that. You can catch me at cocktails if you want to talk about them. But this is a real dispute here. And I think what all of this means, and I again speak as an outsider that travels to India quite a bit and does quite a bit of India-related work, is something exciting is happening here in India with respect to arbitration. When I speak at conferences in the US and the UK where I work, they're often quite boring. The law and practice of international arbitration in those jurisdictions is a bit ossified, it's a bit reified. People think they've figured it out, and they don't need to change how things are. Here, there's a very different mindset. People want to make this jurisdiction one of the most attractive and competitive jurisdictions for international arbitration. And because of that, there's really interesting thought that's happening here, thought leadership. There's very interesting judicial opinions that are being issued. And it's out of this sort of milieu that this handbook that we're here to celebrate today has emerged. And I congratulate Shashank for putting this incredibly well-curated book together. It's a handbook that operates on multiple levels. It's a resource for arbitrators. It's a resource for practitioners that want an insight into the mindset of arbitrators. And it's a resource for scholars that are thinking about and talking about all of these issues. Shashank has gotten together a truly incredible group of contributors. It's not an easy thing to do. So congratulations to him. I think this book and hope this book will make a valuable contribution to the scholarship of arbitration, both here in India and also outside of India. So with that, I'll turn it over to the honorable justices to the Supreme Court. But thank you to Shashank. I should also say thank you to my wonderful co-author, Montek, and it's a pleasure to be here today. Thank you all.
Thank you, Mr. Beale, for your kind words. Our next speaker for the evening, who is also the contributor to the book, is Honorable Mr. Justice B.R. Gavai. Justice Gavai enrolled as an advocate in 1985 and primarily practiced at the Nagpur bench of Bombay High Court. He served as a government pleader and then government prosecutor for Maharashtra government. Justice Gavai was appointed as a judge of the Bombay High Court in November 2003. He served as a judge of Bombay High Court for 16 years before being elevated to the Supreme Court in May 2019. Ladies and gentlemen, please welcome to the dais Honorable Mr. Justice B.R. Gavai.
The dignitaries on the dais, the dignitaries of the dais, all the learned contributors and friends. It gives me a great pleasure to be with you all on this occasion of the book release of the Arbitrator's Handbook. At the outset, I must congratulate all those directly or indirectly associated with this project for bringing out a treatise on arbitration law. Various experts in the field of arbitration throughout the world have contributed in this project, the outcome of which is the Arbitrator's Handbook, which would provide a realistic, practical guidance for the benefit of many across the globe. The handbook, which consists of 23 chapters, is a compilation of 23 articles authored by judges, lawyers, international arbitrators, arbitration practitioners, and various other expert stakeholders. The handbook is one of its kind as it sets out to provide key guidance to arbitrators across all jurisdictions, helping them understand finer nuances of dispute adjudication. However, this could not have been possible without the hard work of Shri Shashank Garg, a young dynamic lawyer who has earned a niche for himself in the field of arbitration at such a young age. The handbook is the brainchild of Shashank Garg, and I must congratulate him for this initiative of his. The handbook deals with chapters which cover various aspects of the arbitration laws. For instance, the book has chapters right from very basis of arbitration, that is the laws applicable to arbitration and appointment of arbitrator, to the age-old debate surrounding arbitrability, competence, and allocation of costs and awards. Even the concepts of emergency arbitration, anti-arbitration injunction, role and use of experts are discussed in great detail. And the icing on the proverbial cake are the incredibly helpful and unique chapters written from a purely practical perspective on conduct of arbitral proceedings, taking of evidence, drafting of arbitral awards. Such a widespread discussion on varied themes and areas of law is indeed a rarity. I have no hesitation in saying that this would truly be a one-stop shop guide for arbitrators of all ages and all jurisdictions who deal with arbitration on a daily basis. And I must say, it is a matter of pride and honor for me to be associated with this project. I would like to thank the editor, Shashank Garg, for extending an invitation to me to make a small contribution to this work, which otherwise features true global stars of arbitration and litigation. I think this is a very timely and much needed addition to the dynamic field of arbitration. Mr. Beale has already thrown light upon arbitration in general in his opening address. Legal historians bear testimony to the fact that arbitration is not new to India. Its roots go way back to the ancient times. But as far as statutory recognition is concerned, from as early as Bengal Regulation Act of 1772, which provided for reference of disputes to the arbitrators, to the Indian Arbitration Act 1899, which was a replication of the then prevailing English Arbitration Act, arbitration has had a firm foothold in the Indian legal history. The foothold was strengthened with the Arbitration Act of 1940 and ultimately gained global recognition with the Arbitration and Conciliation Act of 1996, further ameliorated by the 2015 amendment to the 1996 Act, and more recently, the 2019 amendments. While the arbitration mechanism and procedures were improving all this while, and at the domestic level, arbitration gained rampant acceptance, there were, of course, quite a few shortcomings, which resulted in the stunted growth for international acceptance of India as a preferred seat of arbitration. The learned law minister has already referred to various aspects on this issue. One of the major factors will be the way that the courts at the seat deal with matters relating to arbitration, be it appointment of arbitrators, grant of interbliefs, enforcement of awards, or more significantly, adjudicating on challenges to the award. The supervisory courts of the seat have a key role to play. More specifically, when it comes to challenge to an award, there are many considerations at play when viewed from the point of view of different stakeholders. From the party's perspective, identifying the right forum, making out the grounds for challenging the award are key considerations. Whereas from the perspective of the court, adjudicating the challenge, it is crucial to see whether the grounds for annulment are made out to the satisfaction of the court and whether other considerations of equity and justice, balanced with the private nature of arbitration, have also been accounted for in the award. I'll briefly touch upon the latter part, that is the court's role in adjudicating on a challenge to the award. Even a bare perusal of Article 34 of the Institutional Model Law and Article 5 of the New York Convention would respectively show the grounds for setting aside, the grounds for refusal of enforcement. The often invoked grounds are arbitrability and public policy. Both of these are intertwined in the realm of arbitration law. When it comes to arbitrability, the Supreme Court in Booz Allen and Hamilton versus SBI Home Finance very astutely observed the scope and meaning of the term arbitrability after an exhaustive review of international jurisprudence on the subject. These chiefly being substantive arbitrability, procedural arbitrability, and arbitrability as per the arbitration agreement. Of course, all of these things being subject to the prevailing public policy of the state, a concept about which much has been written and discussed in extenso. A decade ago, there used to be a lot of debate surrounding the scope and extent of public policy, especially as interpreted in India. In the last few years, however, the courts have done a fairly commendable job in interpreting the concept of public policy in the backdrop of prevailing international jurisprudence. Of course, concepts of patent illegality, conscience of the court, fundamental public policy of the country are rather wide concepts. But to single out the Indian courts for criticism for giving these concepts a wider purport would not be justified. I may also refer to the judgment of the Supreme Court of India in Sangong Engineering and Construction Company Limited versus NHAI, which read an inherent limit in the very concept of public policy and defined the scope of review of the award, very similar to the decisions rendered by the Privy Council in Betamax Limited and by Singapore High Court in AJU versus ATI. It could thus be seen that the courts in India have been proactive in their support of arbitration by defining the scope of interference in adjudicating challenges to the award, thereby doing their bit in the overall push to make India a desirable seat. While undoubtedly this push for being a desirable seat must continue with full force, we must also be mindful that just like any other major arbitration jurisprudence, the chief majority of arbitrations in any state will always be domestic arbitrations. Therefore, it is a bounden duty to ensure that at the domestic level too, issues and challenges which might arise in the arbitration ecosystems are addressed at war footing from both corners, the legislative and the judicial. And in order to ensure that Indian domestic arbitration also flourishes, of course, there is a clear need of quality arbitrators who are well versed with both domestic and international procedures. I firmly believe that this book will be a major source of information and guidance for many such arbitrators in India and abroad who are looking to learn from the best and to do their bit for development of arbitration law. I thank the organizers for giving me this opportunity to be with you this evening And I wish all the success to everyone associated with the book. Thank you very much.
Thank you, Lordship, for your encouraging words. The next speaker, and also a contributor to the book, is an alumnus of Campus Law Center, having been called to the bar in 1983. During his years at the bar, he has practiced before various forums in a wide range of areas, including arbitrations, writs, tax matters, commercial disputes, environmental matters, and also acted as a prosecutor. He was elevated as a judge of the High Court of Delhi in 2005 and then to the Supreme Court in 2019. Please welcome to the dais Honorable Mr. Justice Sanjeev Khanna.
Namaste and a very good evening to you all. Honorable Mr. Justice U.U. Lalit, Honorable Mr. Justice Sanjay Kishan Kaul, Honorable Mr. Justice B.R. Gavai, respected judges, retired and sitting, distinguished professors, advocates, guests, and dear students. I begin my address with a caveat, which I had also expressed to Mr. Shashank Garg when he had approached me for contributing a chapter for the handbook. Arbitration is a subject which we encounter day in, day out as judges. Authoring a judgment is very different from writing an article. Judgments invariably are statements of law with coherent explanations, whereas analyzing a legal position in an article or a chapter should be in the nature of a critical commentary, deconstructing the statements of law reflected in the judgments. As a jurist or as an author of academic work, one is entitled to question the basis of the suppositions underlying the reasoning in the judgment. It is of vital importance that experts in the judgments should be free to air their views and make critical comments without any constraints. As judges, we enjoy a great flexibility while interpreting law as we make law, but the nature and the reasoning is different, and we are bound by the law of precedence. Just like a judgment, a handbook should be starting point of critical scrutiny and comments. For any insightful critique, including disapproval, is of valuable assistance for the growth and development of law. Such evaluations are indispensable and needed by the bench and the bar. It also follows that my brief address as a student of law would pose some questions which I would expect you as critical thinkers to ponder and find your own answers. The law of arbitration in India since 1995 has been in constantly evolving and adapting to ever-growing needs and challenges. Many of us believe that it is getting better and more litigant-friendly. However, given the amendments to the Arbitration Act that the Arbitration Act has seen in 2015, 19, and 21, and the divergent and dissimilar views expressed by various courts, one would say that it is in the stage of constant experimentation. This has shown up interesting challenges which make the law of arbitration exciting and stimulating for both the lawyers and the judges, but to some extent at the cost of uncertainty and unpredictability. While growing up as a school student, we were told that in a constitutional democracy such as India, everyone has the right to access the courts to get their disputes decided and adjudicated. This right to access the courts, presided over by a competent, impartial, and independent decision maker called the judge, is an unequivocal and important right. And an unbiased and a fair adjudicator is a protector of constitutional and statutory rights. This ensures and gives confidence to the public to get what they are entitled to, a well-reasoned, just, fair, and unbiased decision. Naturally, I was taken in for a big surprise when in the first semester of my law school, Section 28 of the Indian Contract Act 1872 came to my notice. This section provides that an agreement in restraint of legal proceeding shall be void. But exception 1 to the section envisages that jurisdiction of the courts of law can be excluded in matters where the parties have agreed to arbitration. As a law student, I felt there was a conflict on one hand where we were taught that access to courts of law is a valuable and an inalienable right, while on the other hand, the Contract Act does not disapprove of a prohibition or a bar on approaching the court when there is a mutual agreement to arbitrate. In other words, the right to access the courts has been equated with the right to access arbitration. This statement of law is of significance and importance and perhaps has been somewhat overlooked. While studying in the law school, I could not understand the jurisprudence of equating access to arbitration with access to courts, nor was this explained to us. On consideration, it appears that exception 1 to section 28 accepts that arbitration is one of the oldest, if not the first method known to the society for adjudication and resolution of disputes between two or more persons. Existence of disputes, disagreements, and conflicts, which are organic to human beings, mandates a need for resolution. This need, it appears, gave rise to arbitration mechanism for adjudication by a third person whose opinion and decisions should be respected because of his stature, impartiality, and independence. This is evident from the Great War of Mahabharata, which was preceded by Lord Krishna's valiant attempt as an unbiased arbitrator, cum mediator, in seeking reconciliation of disputes through means alternative to war. Similarly, in ancient India, we have 3 grades of arbitrators mentioned in the Smriti, Puga, Sydney, and Kula, all of which had one thing in common: resolution of disputes by respected and impartial members of the society. Given the fact that arbitration has existed for thousands of years, one would have thought arbitration as an alternate dispute resolution mechanism would be the default or the conventional norm, and the court litigation and adjudication the second choice. Is that so? My answer, obviously, and we all know the answer, it is no. We do not have pan-India data regarding the civil disputes being referred to arbitration. The undisputed fact is that only a minuscule percentage of civil cases instituted in Indian courts get referred to arbitration. This is in spite of enactment of Section 89 of the Code of Civil Procedure, as well as mandate for commercial arbitration in some enactments like the Micro, Small and Medium Enterprises Development Act 2006. From the data from the National Capital Territory of Delhi, which has a thriving arbitration culture and acceptance, is revealing. In the year 2018, that's pre-COVID times, as many as 105,697 suits were instituted in subordinate courts, while 3,964 suits were instituted on the original side of the Delhi High Court. As opposed to these figures, barely 489 matters were referred to the Delhi High Court International Arbitration Center in the same year, thereby increasing the cumulative reference to the said center to mere 2,378. And we talk about Delhi High Court Arbitration Center being the leading center in the country for institutional arbitrations. Today, there are about 12,523 civil suits pending in the Delhi High Court, and about 92,700 civil suits pending before various subordinate courts in Delhi. As opposed to this, in December 2021, we had merely 3,704 cases which were listed before or referred to the Delhi High Court Arbitration Center. To this figure, I would concede that we should at least 2 times the number of references made to ad hoc arbitrations, since most of the arbitrations in India, in spite of the 2019 amendment to the 1996 Act, are ad hoc arbitrations. Consequently, arbitration would constitute about 1 to 1.5% of the total civil disputes which are filed and are pending before the civil courts. It is therefore quite clear that the arbitration as a method of alternate dispute resolution has not been preferred and accepted by the litigants. It has not gained acceptance in the manner it should have been welcomed as an alternate to court adjudication. This is in spite of the fact that court litigation is time-consuming and often very costly. The three main reasons with the arbitration process that worry a potential litigant, I believe, are A, partiality of arbitrators, B, preference of ad hoc arbitration over institutional arbitration, and C, high costs and delay in arbitration proceedings. However, the evolution in legislature and the courts have made successful attempts to allay the deficiencies in the arbitration process. In the present address, due to paucity of time, I would concentrate on the aspect of independence and impartiality of arbitrators. The reluctance to adopt arbitration stems from the legacy that it has carried for years. As Justice R.V. Ravindran, while penning down his article, What Ails Indian Arbitration, notes that during the application of the erstwhile Arbitration Act 1940, arbitrations were opted mainly when disputes arose between independent contractors and the governments or public sector undertakings. Justice Ravindran wrote, and I quote, "But in India, many arbitrations relating to claims against the government or statutory authorities of government companies, the quality of defense was found to be wanting when compared to the quality of prosecution of claims. The Ministry of Law and Justice, Government of India, has adverted to this aspect in the national litigation policy. Instances are also not wanting where some officers of the government, either as arbitrators or as officers in charge of the defense, were colluding or were sympathetic towards the contractors or claimants. Courts repeatedly found that the inexplicable huge awards were being made against the government though not warranted. Sometimes such awards were made even in arbitration between private parties. Having regard to the limitations with regard to the interference placed under the Act, it was very difficult to interfere with such awards, and the claimants were found to be walking away with huge undeserving awards. We must also accept there are issues of appointment and nomination bias, which have on occasions met judicial acceptance. By relying upon principles of mutuality and party autonomy, these require a deeper and a greater debate. What is true about the arbitrations in which government was one of the parties is equally true when the arbitration is between two private parties. The Bombay High Court has a reported case found that a private sector finance company has appointed one person to act as an arbitrator in almost 250 matters. However, in his disclosure to the parties, the arbitrator has misinterpreted this number as being merely 8 cases. Studies backed by growing empirical data show the existence of affiliation bias among arbitrators. Affiliation bias is defined as cognitive predisposition in favor of the appointing party. This is a case where the appointed arbitrators find it difficult to maintain impartiality because of implicit preferences for the party that appoint them. In general, the modern psychology has extensively documented the existence of implicit biases in a variety of things, from sympathetic attitudes towards specific groups to certain beliefs. In case of affiliation bias, arbitrators, despite their best intention to remain unbiased, are primed to favor their nominating party, simply by knowing that they were selected by that party. A 2017 survey by a university in the United States of America has found that in the field of arbitration, the frequent use of party-nominated arbitrators is likely to result in litigant-induced bias. Being appointed by one of the parties directly changes the behavior of the arbitrators, and thus the appointment itself is the cause of some of the bias of the arbitrator towards the appointing party. To counter this, the study suggests use of blind appointments, that is, not disclosing the appointing party to the arbitrators. This, it is believed, would help circumvent affiliation bias while retaining the benefits of the party involvement in the appointment process. Thus, in order to ensure that all sorts of biases are removed from the arbitral process, we must get sensitized to the notion that affiliation bias could potentially act as a blot on independence and impartiality of arbitrators. I had come across a very interesting quote from one Justice Black of US Supreme Court, and I'm tempted to quote it over here. It is true that the arbitrators cannot sever all their ties with business world, since they are not expected to get all their incomes from the work of deciding cases. But we should, if anything, be more scrupulous to safeguard the impartiality of the arbitrator than judges, since the former have a complete free rein to decide the law as well as the facts and are not subject to appellate review. Having said so, we must take note of the fact that unlike the 1940 Act, the mandate of Section 31(3) of the 1996 Act now requires an arbitrator to state the reasons on which it is based. Passing of a reasoned award is not an empty formality under the Arbitration Act. The requirement of a reasoned award are that the reasoning should be proper, intelligible, and adequate. Though this mandate is not to be mistaken with a court judgment, the requirement puts a check and ensures that the award is fair and impartial. More significant are the 5th and the 7th schedule of the 1996 Act as added by the 2015 amendment that postulate various criteria for determining independence and impartiality of arbitrators. In cases of the 7th schedule, an application can be directly filed before the court under Section 14(2) for terminating the mandate of the arbitrator, since such an appointment is inherently invalid. However, in case of 5th schedule, any justifiable doubts are to be determined under Section 13 by the arbitrator concerned. For this, the Supreme Court has devised the commonsensical approach for determination of independence and impartiality of arbitrators, and on interpretation and application to be given to the words in the 5th and the 7th schedule. The Supreme Court in Westall Alpine versus Delhi Metro Rail Corporation expressly observed that the independence and impartiality of the arbitrators are the hallmark of any arbitration proceedings. Justice A.K. Sikri, who's sitting here, is the author of that judgment. The next two judgments are by Justice U.U. Lalit in the case of Perkins Eastpen Architects and Aravali Power Company Private Limited. Both judgments affirm and carry forward this principle. On the same line is the reasoning given in TRF Limited. I will skip some portions of, I've taken out some quotes, but I'll skip those. But while I concede that there's some concerns which have been mentioned above are not completely unfounded, I would certainly disagree with the notion that arbitration is not one of the most efficient and convenient modes of dispute resolution. Every method of dispute resolution has positive and negative facets. There are several amongst us who believe arbitration is better than court adjudication. To substantiate, one may give the following reasons. 1. It avoids technical rules of procedure and evidence and gives flexibility. 2. It results in binding dispute resolution with limited ground for challenge. 3. It allows the parties to choose their own arbitrator. 4. It gives the choice to have specialists and technical experts as adjudicators who can appreciate and understand the technical issues and therefore promotes practical decisions. 5. It cuts delays and costs and does not involve any court fee. 6. It gives choice with regard to the venue, scheduling, and timing of hearings to suit the convenience of parties. 7. It provides a non-hostile atmosphere, making the parties' witnesses comfortable and conducive to settlement. Further, it is pertinent to note that the government policy as reflected in the Statement of Objects and Reasons for 1996 Act is to encourage arbitration and to bring the Indian arbitration laws in tune with the international standards. The Department of Legal Affairs, in its policy on arbitration available on the website, rightly sums up the reasons for India's inclination towards arbitration. Litigation route is lengthy process leading to unnecessary delays in disposition of justice as well as overburdening of judiciary. In such a scenario, alternate dispute resolution mechanisms like arbitration, conciliation, and mediation come in handy. These ADR mechanisms are less adversarial and are capable of providing better substitute to conventional methods of dispute resolution. Though I would concede there is some reluctance amongst us, there's reluctance in some of us to think of arbitration as a default dispute resolution mechanism. As a result, those who are aware of the advantages, they are reaping the benefits of arbitration, whereas those who doubt arbitration continue to proceed to courtrooms. Before I end, I'd like to commend the efforts put in by law clerks, former law clerks, Mr. Ayush Malik, Mr. Rajat Baniwal, and Mr. Pravant Tanar, without whom properly I would not have been able to score and write down my article. And I must congratulate and give my good wishes to Mr. Shashank Garg, who's really put in a lot of effort to compile this handbook. I was going through the chapters. They're full of information, critique, and I'm sure this is going to be a valuable addition to the books we have on arbitration. Thank you so much.
Thank you, Your Lordship, for your insightful words. The next speaker for the evening is Honorable Mr. Justice Sanjay Kishan Kaul. He is also a contributor to the book. Justice Kaul enrolled as an advocate with the Bar Council of Delhi in July 1982 and practiced primarily in the Supreme Court and the Delhi High Court. During his 19-year-old practice, he handled mainly commercial, civil, and writ matters. He was designated as a senior advocate in December 1999. Justice Kaul was then elevated as a judge of the High Court of Delhi in May 2001 and was subsequently appointed as the Chief Justice of Punjab and Haryana High Court before being sworn in as the Chief Justice of the Madras High Court in July 2014. In February 2017, Justice Kaul was elevated as a judge of the Supreme Court. Ladies and gentlemen, please welcome to the dais Honorable Mr. Justice Sanjay Kishan Kaul.
A very good evening to all of you, brother judges, on the dais, off the dais, former judges, members of the bar, ladies and gentlemen. Let me first compliment Shashank Garg on goading us and following up with us to make sure we write something and write in time. That itself is a great challenge with judges. The organizers felt that I can give some kind of a capsule or summary of what I and my co-author have written, considering Brother Gawai has given an overview of the book to avoid any repetition. The topic is also more relevant because of something which the Law Minister also said in his opening remarks, which is to what extent arbitrations are to be impeded by judicial interventions. The article which we have written is on the issue of anti-arbitration injunction. This is a jurisprudence which developed at some stage of time, though intervention by court in arbitration and preventing an arbitration where arbitration is being promoted, there's some kind of an anathema to each other. But the Law Commission of India also in its report, 246 report, has said the same expression, anathema to arbitration. Scholars have spoken in favor as well as against. Sometimes there are situations where it is felt that intervention of the courts become necessary, but the boundaries become itself a little problem. So we have international scholars saying that it is an inefficient and possibly harmful intervention. On the other hand, there are also some people who feel through judicial pronouncements that this is an important and valuable weapon in the hands of the court exercising supervisory jurisdiction over the arbitration, in the words of Lord Hoffman. Now, dragging a party to an arbitration when there is no arbitration agreement is one of the areas of concern. Because why should he be made to go through arbitration when there is a issue of being party to the arbitration itself? The judicial machinery provides an essential support to the arbitral process. And arbitration requires that judges interfere only when required, and this is true in any form of arbitration. We've also had a scenario where the arbitration regime, how it has to operate in the Supreme Court itself, has seen many turns and rounds, till we came down to a situation with statutory amendments and judicial interpretations that it's not the job of the judge to sit as an appellate court and scrutinize it, because the arbitrator is a chosen judge by the parties. That's the whole premise on how it works, and that's something I believe in, and that's why I'm referring to it. The Act of 1940 and the Act of 1996 had specific provisions barring suits earlier. Yet the whole concept of this anti-arbitration injunction area developed jurisprudentially. Both our country and I think world internationally, there is a pro-arbitration environment. It's not only because the courts in our country are very overloaded, or that in other courts we have developed a system by which people have been able to take this litigation out and feel that this is how it should operate. So, for example, on my visit to the US courts in an exchange program, 97% cases go out of the court system, either by mediation or arbitration or alternative dispute resolution mechanism. And for commercial litigations, the arbitration is perceived to be the better remedy because it's a little more informal. The people who are arbitrators can be persons who are experts in their field. A judge is often a man of all seasons. He's a harfanwala. But he may not be a specialist in that particular field. And there are so many areas of concern which have developed over a period of time. And arbitration in those areas of commerce where some of us had never had an opportunity to practice, because those areas itself evolved over the last decade or 2 decades. So people who are in the field at times are able to handle it better. And that's the importance why I think only judges are not arbitrators. Many others perform very good roles of arbitrators. The concept of a permanent injunction being granted has to follow in some principles under 41H of the Specific Relief Act. So, modeled on that principle, a development has taken place as to how an injunction should or should not be granted. There have been judgments of this Supreme Court in the Kavanagh Cementation India Limited, which though passed in 2001, wasn't reported till the year 2012. And a suit was filed seeking a declaration that no arbitration agreement existed between the parties. The Supreme Court held that civil court cannot have jurisdiction to go into the question of existence or validity of the arbitration agreement after taking into consideration the very object with which the 1996 Act had been enacted. The fact that it was not reported is surprising because today everything gets reported, orders, judgment, everything, 20 volumes of SEC. There were sometimes different to those earlier times. And before this judgment, the majority in the 7 judges bench of Supreme Court had held that Section 16 of the Arbitration Act only makes explicit what is otherwise implicit, namely that the arbitral tribunal constituted under the Act had the jurisdiction to rule on its own jurisdiction, including ruling on objection with respect to the existence of the validity of the arbitration agreement. The decision of the Supreme Courts have been interpreted by high courts in a manner to justify diametrically opposite views regarding the issue of maintainability of an anti-arbitration suits. Some courts are more incessant of these disputes, and some of the metropolitan towns have a larger area of litigation in this area. So while courts in a sense have battled over whether they have the power to grant anti-arbitration injunction, one aspect which is generally agreed to is that the power should be used sparingly and with abundant caution in exceptional circumstances. I do believe that it's a time when we talk about creation of expert tribunals. Those experts are not manning the tribunals is a different matter altogether. But with such a wide spectrum of litigation pending in courts, possibly it is time that in the appointment process and otherwise we take care of people of that field. And sometimes it's necessary that in some nature of litigation, people who have handled that litigation are made to sit as judges to handle it. That's the basis of a tribunal, whether you create a tribunal separately or you create divisions in the High Court which can help in sorting out the problem of litigation in specialized field. I would personally feel the second is a better option, seeing how tribunals have been working, exceptions apart. Courts in England and United States and Australia have exercised powers to grant anti-arbitration exemption only in exceptional circumstances. And even in cases where arbitration proceedings under bilateral investment treaties were sought to be restrained and consequently the 1996 Act was not applicable, the courts generally envisaged that anti-arbitration suits are maintainable. However, they have always extended a caution that interference and ultimately declined to restrain proceedings. In cases where courts have held anti-arbitration injunction suits to be maintainable, it's in very rare cases that there is a restraint in arbitration proceedings. However, the ambiguity and conundrums are likely to continue unless the Supreme Court clarifies some of these aspects. Until then, the debate has to continue. COVID times have not been the best of times for us to come to a conclusion one way or the other, dealing with the exigency of the situation. I congratulate all the contributors in creating a handbook which will be useful in the arbitration process, because I believe mediation and arbitration processes are not there only as an ADR, but are actual areas where litigations can be sorted out, because there are better methods of resolving the disputes than the courts sometimes, leaving the courts to concentrate on what they're supposed to do, which are largely a different nature of matters. Thank you for giving me this opportunity to be here, and let me apologize to Brother Lalit, which I've already done. I have to take a flight to go to my second home, which is Chennai, for a function. So I'll have to leave somewhere in the middle. Maybe I'll be able to hear him for some time. Thank you very much.
Thank you, Lordship, for your enriching words. We would like to invite to the dais today's guest of honor, Honorable Justice UU Lalit, to share a few words. Justice Lalit commenced his practice at Bar in Bombay in 1983 and then moved to Delhi in 1986. He was designated as a senior advocate by the Supreme Court in 2004. He has, during his practice, served as an amicus curiae and also as a special public prosecutor. He was elevated as a judge to the Supreme Court in 2014. He also served as a member of the Supreme Court's Legal Services Committee for 2 terms. In May of 2021, His Lordship was appointed as the Executive Chairman of the National Legal Services Authority. His Lordship has since extensively worked towards enhancing access to justice. Please welcome to the dais Honorable Mr. Justice UU Lalit.
My esteemed colleagues, Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna, and Justice B.R. Gavai, who have also contributed to this brilliant work, all the former judges of the Supreme Court, the present judges of the Supreme Court, the honorable judges of the High Court, professors, distinguished persons, senior counsel, ladies and gentlemen. You know, years back I had read foreword written by Jamshedji Kanga to a brilliant work done by Palkhiwala, who was, before in his early 30s, he had come out with what is called Kanga Palkhiwala on income tax. And the foreword goes something like this. Kanga says, after a horse has won the race, a derby, somebody just takes the horse and the rider to the podium so that the medal or the award can be given to that horse and the jockey. After all these speeches, I just feel like what Kanga must have felt in just concluding the day's deliberations today. You all must be tired. There's a limit to somebody's endurance. So I'll just quickly place some of the recent features, and that must be something as a student on arbitration on this branch, we must notice some of the recent trends. And that's the only thing that I can say in about 5 minutes' time. And pardon me for that. Yes. One of the trends is on dichotomy in multi-tier or escalation clauses. 2 judgments recently. One by the English High Court and the other by Hong Kong High Court. One in that SL mining case and the other Hong Kong judgment in C versus D. Both these judgments have settled an important debate by clarifying that non-compliance with pre-arbitral steps in multi-tier clauses does not go to the root of an arbitral tribunal's jurisdiction, but it is a matter of the admissibility of parties' claims, or rather, the forum to decide such admissibility being the arbitral tribunal and not English or Hong Kong courts. Very often we encounter these problems. These decisions have provided welcome certainty on the issue of disputes arising out of non-compliance with pre-arbitral tiers in escalation clauses. They also reflect the pro-arbitration stance of the English and Hong Kong judiciary. Second, that is access to justice and arbitration. In a very landmark decision just about a fortnight or maybe a month ago, whilst dealing with a case concerning the German ice skating champion, the German Federal Constitution Court held that the mandatory arbitration clauses of the Court of Arbitration for Sports was null and void because the relevant arbitration rules did not provide the right to have a public hearing, thus violating the athlete's constitutional right of access to justice pursuant to Article 2(1) read with 20(3) of the German Federal Constitution. Very important judgment. The significance of this judgment lies in its stand that where there is an imbalance of power between the parties of an arbitration agreement, it is critical to ensure that fundamental rights of the weaker party are duly protected and the law must step in to restore the equilibrium of the bargain. What remains to be seen, however, is whether this ruling will be used as a yardstick to challenge validity of arbitration clauses in contexts other than sports arbitrations, where there is a structural imbalance of bargaining powers amongst the parties and one side has no choice but to accept an arbitration agreement. It's a very significant development on international commercial arbitration scenario. Then the third, approach to determining the proper law of arbitration agreement. This is a decision of October 2020 by UK Supreme Court, which clarified the applicable principles for determining proper law of an arbitration agreement. In a way, the judgment challenges the seat approach which has crystallized in our Indian jurisprudence. Although some have argued that this UK Supreme Court decision has set aside previous uncertainty prevailing on the issue and put in place a straightforward and a clear approach, in particular reference to India, it poses a relevant question, namely, whether our courts need to review their position and explore a more nuanced approach to the existing paradigm of seat approach for determining the law governing an arbitration agreement. Now turning to the fourth one, that is apparent bias test. In an important pronouncement, again by the UK Supreme Court, which is of 2020, it refined the test of apparent bias in the context of arbitration, rejecting the challenge made to the presiding arbitrator on the ground of repeat appointments. This is something which Justice Khanna also touched upon that issue. The UK Supreme Court, confirmed that an arbitrator was under a duty to disclose facts and circumstances which would or might reasonably give rise to the appearance of bias. And 2, it ruled that the duty of impartiality applied in the same way to every member of the tribunal, observing that, quote, the party appointed arbitrator in English law is expected to come up to precisely the same high standards of fairness and impartiality as the person chairing the tribunal. Now, these are the significant developments. It also noted that while professional reputation and experience of an individual arbitrator was a relevant consideration in assessing whether there was apparent bias, it cautioned against according heavy weight to this factor in determining arbitrator challenges. The fourth, and that is so far as the trends in Indian scenario are concerned, our courts have made significant strides emphasizing a pro-arbitration approach. 3 crucial recent judgments of the Supreme Court are a testament to this. Number 1, PASL versus GE, allowing 2 Indian parties to elect a foreign seat of arbitration. Number 2, Amazon versus Future, confirming the enforceability of emergency arbitrator awards in India-seated arbitrations. And 3, Vishnu Constructions, directing Indian high courts to clear backlog of pending arbitrator appointment applications under Section 11. These trends reflect a positive change. These are questions that remain to be answered, which will hopefully be clarified as and when they arise in future disputes. For instance, autonomy of 2 Indian parties to choose a foreign substantive law to govern their contract and enforceability of emergency arbitrator awards in foreign seated arbitrations. Then the 5th one, discovery of evidence in international commercial and investment arbitrations. This is a very significant judgment which has recently been delivered. This came in June 2022. US Supreme Court unanimously ruled in ZF automotive case, that US discovery law, US discovery cannot be ordered under one of the sections, that is 1782, in aid of international commercial arbitration and investor state arbitrations. resorting to a very constricted and narrow interpretation, the Supreme Court held that under that relevant section, foreign or international tribunals only referred to governmental or intergovernmental adjudicative bodies and did not include international arbitral tribunals. This judgment is a crunch point for gathering of evidence in international arbitrations. With private commercial arbitrations clearly held to be outside the bounds of said section 1782, it will be interesting to see whether the factors culled out to demarcate a tribunal as a governmental or intergovernmental adjudicative body will also apply to evidence gathering processes of specialized international tribunals such as bodies entrusted to handle international criminal law or even ICSID tribunals. Now, these are some of the recent trends which are prevalent. Of course, I am throwing these points for further deliberations at a future date. What today we have gathered is to celebrate this launching of this book. It's a wonderful compendium. 3 of the contributors are present with us on the dais. There are other contributors like Justice Sikri, Justice Vibhu Bhakru, Gaurav Banerjee. It's a brilliant piece of work. As I said right in the beginning, I am only taking the horse to the podium. Mr. Shashank Garg, you have done a brilliant job. Congratulations and thank you all of you. Thank you.
Thank you, Lordship, for your enlightening words. I now invite the man of the hour, without whom today's event would not have been possible, Mr. Shashank Garg. Ladies and gentlemen, please welcome Mr. Shashank Garg for a vote of thanks.
Good evening, everyone. Honorable Justice Lalit, Honorable Justice Sanjeev Khanna, Honorable Justice Gawai, Honorable Justice Kaul, who had to leave for a flight to Chennai, Honorable Law Minister who had to leave early. We had to change the program because he had a meeting to attend at 5:30. I've been reminded this is a vote of thanks and I have no intentions of breaching that. I will keep it as brief as possible. Everybody who's present here is either a well-wisher or a mentor to me. Therefore, most of you know the story of this book, how this was conceptualized. The idea of this book was to fill the vacuum that I perceived was in the market where there was nothing particularly for the arbitrators. All the books were either commentary on the 96 Act or were on international arbitration. But as and when you pick up that book, they would start from the concepts from the point of view of a practitioner or how to build your case before an arbitrator or in a 34-17 proceedings, but nothing really that would answer questions of an arbitrator. Of course, most of the arbitrators that we see are very seasoned arbitrators, former judges from Supreme Court and various high courts of the country. And they don't need that sort of orientation and training. But we also have an ample number of technical arbitrators and other arbitrators who are not seasoned former judges. And therefore, there was a vacuum that we felt should be filled. And with this idea, I reached out to some of the most distinguished, eminent minds in India and abroad. And as you can see, you've heard the honorable judges who are on the dais, you've heard the law minister, you've been seeing the presentation that has been played, which shows all the contributors who've taken out time to contribute to this book. Now, Another aspect that I thought of before I was coming to the stage was that we started at 5, and I think we'll finish in next 5 minutes, which is an indication of adhering to punctuality, something we all need in arbitration, something that the government of India has been promoting, something the Supreme Court and the High Courts through their judicial pronouncements have been promoting, and we are achieving that. So if we can start events like these on time and finish on time, so can we with the arbitration. And I think all the stakeholders, including the lawyers and arbitrators, will have to take that pledge in future as well. Now I've made a list of people I must thank so that I don't miss out on anyone. Of course, there are many people who have helped me put this book together, other than, of course, the distinguished contributors. I would not be able to thank each one of them. I have thanked them in the acknowledgements in the book. But in particular, I would like to thank Honorable Justice Sanjay Kaul, Honorable Justice Sanjeev Khanna, Honorable Justice B.R. Gawai, Honorable Justice A.K. Sikri, Honorable Justice Vibhu Bhakru. Some of the notable contributors from the judiciary were present here. Of course, Mr. Gaurav Banerjee, my friends who have contributed, Ken Montek. I also must thank the reviewers of the book. The foreword was written by none other than John Beachy. The introduction was written by Claudia Salmon, the first woman ICC president. Honorable Justice D.Y. Chandrachud, who wrote the review for the book. Honorable Justice Krishna Murari, who was with us, had to leave a little early. Honorable Justice Vikram Nath, who's here with us. Honorable Mr. Justice Satish Chand Sharma, Mr. Gary Bond, Mr. V.K. Raja, Mr. Professor George Berman, and Mr. Alexi Moore, who are not here present but are likely to be either tuned in or would be watching this telecast later on. Before I part, I would also like to thank Bar and Bench, Pallavi and her team for covering this as a YouTube telecast. Vikas Mahindra and Terrace, their team, for doing the live transcription for us. Something, again, an example of how we need more and more technology if we want faster arbitrations. Arjun, Radhika, Shelja, the team from LexisNexis who made this possible. And I must confess, Arjun was also part of my previous book. He was there at Oxford University Press when I worked on my previous book. He moved on to LexisNexis and helped me navigate through this new publishing house, and I'm very, very grateful for all the support that I received from them. And last but not the least, my family members, my parents and my sister who are here, thank you everyone for joining me. Now I would request everybody to join us for the high tea and cocktail outside. Thank you.